Good morning, everybody. My name is Bruce Broylette, and I'm really happy to be part of this presentation today on a case that Alan Van Gelder and I tried in November of last year. It is the last case that either of us have tried because of coronavirus, and as a consequence, you can see what has happened to my hair since I haven't been able to get a haircut. So just a first tip is get a haircut when you're going to go to trial. I've never tried a case looking like this, okay? But it is what it is.
I'm going to avoid trying to turn my head because I'll have a mullet for the folks. So do not have a mullet for trial would be my other recommendation.
So the person who just spoke, as many of you know, is Alan Van Gelder, lawyer unparalleled in the community, very bright, hardworking, and did a great job of the workup on this case, and then his great work when we were trying the case together. And then we have Claire Plotkin, who brings up the IQ of this group enormously. She has been our jury consultant on this case and a number of other cases that we've tried or settled. She works with us in selecting the jury and in doing the jury research ahead of time. And she did the jury selection in this case, which, as you will hear, carried particular challenges, especially on damages, that were unlike any other case that most of us have had. So having said that, one day I'm sitting at my desk, the office, and I get a message that a woman named Kitty Keck would like to speak with me about the death of her son. And I heard the name Keck and I went, well, could this be the Keck of the W.M. Keck Foundation that I've heard so much about? Next. Could this be the Keck that the Keck Medical Center of USC is named after? Next. That the name is everywhere for everybody to see around LA, the football stadiums. Go ahead, the next one. Keck Medicine of USC as somebody runs for what may be a touchdown. Who knows? We didn't have the rest of this picture. Next. On the back of buses, the Keck name everywhere. Why would, well, is this Kitty Keck? The same Keck that's related to that name, because I'd also been up to look at the Keck telescope, which is located in Hawaii. That was also funded by the foundation. Next. There it is. Next. And then, of course, the W.M. Keck Foundation, that's the longtime sponsor and funder of Sesame Street, that so many kids, including probably some people that are on this particular webinar, grew up learning from and enjoying. The Keck Foundation. Could this be the same Kitty Keck? So I recognize right away two things about the fact that this may be the same Kitty Keck. That is that, number one, if Kitty Keck is part of that world, she had instant credibility with me that she would want to sue over the death of her son. What could have happened that would take a woman of substantial means to a point of wanting to file a lawsuit? There must be something here. Just a reaction I had, which I thought a jury might have down the line. The countervailing consideration was, how are we going to get any meaningful damages for someone where a lot of the jurors would say, well, okay, it was wrong, but why does she need the money? So two countervailing considerations. By the way, it isn't just in Southern California that the Keck name appears, it's all over the place. This was just a small listing of all the universities and facilities that have the Keck name on a program or a building, from Princeton to Michigan to Notre Dame to Vanderbilt to Stanford. All over the country, the Keck name is known. And that was something we were going to have to deal with. Next. So I'm going to turn it over right now to our wonderful jury consultant, Claire, so she can walk you through what we did in terms of jury research and in terms of how we picked the jury.
Okay, thank you, Bruce. So I know that when Alan approached me about working on this case, we realized really quickly that there would be a number of challenges, especially with regards to jury selection. And I don't know, Bruce, if you wanted to give a quick summary of what happened or anything, but
Yeah. Here is what basically happened. It happened at the Bel-Air Bay Club. A 48-year-old single man, Billy Keck, had been playing paddle tennis in a tournament in the morning and qualified for the next round. In the afternoon, he began to show signs of dehydration. Over the course of 3.5 hours, he progressed to the point where he ended up dying, and they had not called 911 and had not moved him to a cool place. He left his 74-year-old mother, wonderful lady, very impressive woman. There was no financial support at all because she didn't need it. And he was, as I said, single. And so she became the only plaintiff for the loss of her son.
right. So, and I know Bruce said he was extremely worried about how to handle damages because she was so wealthy, but Alan and I immediately recognized that there would be some very huge hurdles with regards to liability because this case is not your sort of normal standard PI case, and there's actually quite a few issues that we found to be greatly polarizing with different members of a jury. Some of them being the fact that Billy Keck had heat exhaustion, perhaps for a little bit of time before being in the locker room, and the defendants were arguing that Billy Keck was asked if he wanted to call 911, and he refused. So we knew immediately that even though we had a man lying on the ground in a locker room, which to me was very persuasive that he's in signs of distress, to a lot of jurors, they're going to hear that and think, but he said no. So we knew that was going to be a huge issue. Jurors who would take this case and think, no, it's not his job to say whether or not he needs 911. It's somebody else's job to decide for him, versus those jurors who think, no, it's all on you. It's your personal responsibility to take care of yourself medically. And that was a huge issue for us. And when we did focus group, we did one focus group and we did an online jury research. Bruce did it with Chris Novi.
Right.
And we found that, as we suspected, that men were significantly worse jurors. And I can't say significantly because I didn't do statistics for my focus group, but just from the eyeball test, the men were lower damage, and we had several much worse male jurors, including one who was a terrible defense juror who was an avid exerciser, claims to have lied down on the floor of a locker room before, which I found shocking. But he was arguing the whole time that it's Billy Keck's fault for saying no to 911, and that it's his problem if he is hurt or injured or sick, and he needs to take the initiative to get himself help. So that we knew immediately that was going to be a big problem for us. And I knew from my own experience that men tend to be harder on themselves in terms of taking control. They feel like they need to take control of themselves, and they are way less willing to go to the doctor. So I knew immediately that I was going to be wary of men on my jury. That being said, I'll accept good men. So I won't just strike men willy-nilly, but that was what we came across from our focus groups. And we also realized from the focus group, and I think Bruce and Alan can agree with this, that we needed to shift the way we were thinking about the case in terms of how we viewed the 911 claim, because the Bay Club was saying that Billy Keck said no to calling a 911, but we had nobody who actually could corroborate that was not from the Bay Club. So that was a huge shift in our thinking, that we had to show the jurors that, there's no proof. There's no proof that he said no to calling 911. That's just what they say.
And not only that, we'll get into it in a little bit, but it turns out the story that the club has about whether Billy turned down 911 or not is inconsistent at best. So that came up big later on that we'll talk about.
And one other takeaway we got from the focus group was that we were very wary of jurors who had experienced heat exhaustion. Not to say that we would strike jurors with heat exhaustion, but we wanted to gauge their perceptions of it, because there were a couple jurors who felt like they had experienced way more significant symptoms than Billy Keck had experienced, and we were wary of someone who would say, oh, Billy didn't have heat exhaustion because I had it and mine was this much worse. So that's what we learned from our focus groups. As you can see right here, yeah, one of our worst jurors was somebody who had heat exhaustion walking on the beach and had this very extensive description of all the cramps he'd had that day. And we were worried about that because Billy did not have that textbook description of heat exhaustion. Okay, next slide. So Bruce, do you want me to start talking about how the actual jury selection went? Okay, so we got the venue when Alan and Bruce went to Department 1, we got venued in Santa Monica, which I think at first made everybody really nervous, but we really liked the Judge Lavanas, who was wonderful. And I think ultimately we decided that a Santa Monica jury, if we picked the right jury, would be a little less bothered, perhaps is for the correct term, by Kitty Keck's wealth and Keck Foundation Association. So we were okay with that once we just decided that we were going to accept that judge. But here's some voir dire questions that I wrote for Bruce to ask in jury selection. Has anyone here been in a situation where you could have called for an ambulance or medical attention, but you chose not to? This was a really huge issue in our case. So we wanted, our best jurors were people who chose to call for medical attention even when they thought they didn't need to. So our best jurors were people who erred on the side of caution, and jurors who felt the opposite, that they would decline it, I didn't want on our jury, because I didn't want them to think, oh, that's just what Billy did. And so has anyone here been in a situation where you called 911 where you might not have needed to? Okay, we asked this question in jury selection and it was very effective. I remember we had one of our jurors, I remember a juror who worked for UCLA, I didn't particularly like, except for the fact that he said he saw his coworker show signs of a stroke. His coworker said, you know, I think I'm fine. I think I'm fine. And he said, no, I'm driving you to the hospital. And I think it was a very illuminating discussion amongst the jury. And it was very nice to hear and surprising to how many jurors gave their own examples of how they took somebody to the hospital. And it was very informative for us. And for some jurors, it was very helpful. And we felt more comforted by those people who said, and then next slide, actually. Okay, I don't think that's on here, but we also had a question about heat stroke and heat exhaustion. And I know Bruce and I were very nervous that the heat exhaustion jurors would be bad for us. And actually, I felt like that was a nice surprise. I would say, and Bruce, you might disagree with me, but I would say 80% of the jurors raised their hands that they had seen someone with heat stroke or heat exhaustion. But what ended up happening was we had a really lovely discussion amongst the jurors about how they treated heat exhaustion, the kinds of things they did, which was all extemporaneous, wonderful job by Bruce, but the kind of things they did to get the person out of harm's way. And all of a sudden we had jurors saying, oh, I immediately took them to a cold place. I immediately gave this person cold water. I immediately wiped down their face, and it was a very successful persuasive tool, I think, for everyone listening, that this is the kind of things you do that the Bel-Air Bay Club did not do. But also, we were able to ferret out. There were several jurors who were very like rough and tough types. I remember one of them would like to like dirt bike race and stuff, and he was the kind of person who was like, oh no, I cramp for days on end and I just deal with it. And we knew immediately we didn't want that kind of juror. And I think he ultimately ended up being a cause challenge, but that was definitely something we dealt with. Next slide. Yeah, so show of hands, who here feels that when it comes to medical emergencies, it's better to be safe than sorry? I mean, that was partially to take notes, but partially just to be persuasive. I think almost every juror raised their hands that that ended up being on our panel. Okay, so this is where the fun part of this case came in. So Judge Lavanis did a really different way of jury selection, and one that I actually really loved, and I would love to do it again. But he rather than doing 18 jurors at a time or 12 jurors at a time, he actually had us voir dire, I think it was 27 jurors at once. And I think ultimately that ended up being the bulk of the room once all hardships were done and everything. But so Bruce had to voir dire 27 at once. And I don't think you had a time limit. Is that correct, Bruce?
I do not recall a formal time limit.
Right.
He just said don't waste time. So
right.
Yeah. I mean, I think the bottom line is that the jurors sort of impose their own time limit. There's only so much they can put up with, and you have to be aware of that. But there was no formal time limit.
Right. So, I mean, I would say one negative of doing 27 at once without a time limit is the jury section was longer. And when it comes down to how many hardships we had, which were significant because the case was long, and then the amount of cause challenges, this was a long jury selection. I showed up 5 days in a row. They were not 5 complete days, but there was definitely Monday through Friday was jury selection. And then, but once you just get past that, and Bruce was moving quickly, so the jurors were not upset with him by any means. But what I found interesting was we actually asked Judge Lavanis to, and he agreed, to let us refill seats once someone had been excused for cause, rather than move on and just do strikes. So we did strikes at the very end when we had a full 27. And even though it's a little more exhaustive in terms of time doing it that way, it was wonderful to be able to do strikes and know exactly who's coming up next and map out your strikes perfectly, as opposed to doing 2 strikes here and then refilling and then doing another 2 strikes. For my purposes, it was ideal. So, but unusual. I don't think I've ever done that before. And I think we were lucky that Judge Lavanis and defense counsel agreed. But so when we did this jury selection, I remember looking at Bruce maybe the first morning of actual questioning and being like, this group is grim. But
It was grim.
It was grim. There were, I mean, and there were so many that we didn't like. But luckily, and Bruce will talk about this, we were so lucky, and this is something I've talked about in the past, the importance of cause challenges, because I would say when all was said and done, we may have gotten 15, if not more, cause challenges for this case. And some of them were people who were affiliated with the Bel-Air Bay Club, which should always be a cause challenge. But some of them were people who just really disliked our case. And I want to make a note, because I think this is an important note to make, that we talked about. We did not do a mini opening on this case. I think that, because I've talked before about the importance of mini openings to get cause challenges, but we did not do a mini opening on this case. Bruce and I and Alan discussed it beforehand, and we made a very conscious decision to not do a mini, because we felt that our facts, our good facts, were really great, but the bad facts showed a very negative view of the case that was misleading. One of the only times where I've looked at a case and thought, wow, if you just show the bad facts, this case looks so different, we will lose every juror. They will all think that there's no reason to have this case should come to court. So we did not do a mini for this case. And I think that's an important thing when you're going forward to think of that too. But so anyway, but yeah, when all was said and done, we were able to lose 15, 20 maybe. And I loved the jury that we eventually impaneled. And I think Bruce felt similarly. And it was just shocking how much I hated them on the first day and how many we weeded through to get to what I thought was just a lovely jury by the end.
So a couple of comments here. Number one, we ended up with a mostly female jury. And as you hear the presentation of what I did on damages, you'll see why that is really significant in this case, I think. Number two, there were a couple of moments that in my mind sort of defined jury selection, comments made by a couple of jurors. One of them was, never forget, I don't remember his name, but I remember juror number 1. I can still remember the guy up there. Initially, he looked like he'd be a pretty good juror for us. And then he makes a comment deeper into jury selection where he says, you know, this sounds to me like the rich suing the rich. Why should I care about this? This is like a big production that a rich person can put on, but the average Joe really couldn't put on a case like this. And I wanted to say, hey, listen, normally I'm always representing average Joes, and this is just an unusual situation where this woman who lost her son happens to have some financial strength. But I couldn't say that, obviously, but I used what he said to get other jurors that agreed with him to raise their hands. And I was able to begin to identify those people who would be really tough on damages, even if they found liability, because they saw it as the rich suing the rich.
He was definitely the moment that sort of all the cause challenges happened. Before that, there was not one bit of movement with regards to cause challenges at all. Go ahead.
Yeah, and I've seen that happen before where somebody says something that sounds really negative, and I can use that to get my negative jurors to break cover and to show me who they are by raising their hands and agreeing, and we talk about it a little bit, and that led to the cause challenges. The other thing that happened that was very interesting was that Keck name. So some people were talking about people with money and who cares about their lawsuit, basically. But then a woman in the front row, about 2/3 of the way down the line, said, well, you know what? I am a PhD student, and I've actually gotten 3 grants from the Keck Foundation to do the research that we're working on to help public health. And that comment, and you know, she was very praising of the Keck Foundation and therefore that Keck name. And that caused some other people, you know, I asked, has anybody else heard of the good things that the Keck Foundation does? And people were raising their hands, and I know they do this, and I know they do that. Well, do you know that they sponsor Sesame Street, for example, for the benefit of our kids? And so this whole thing develops into 2 huge, mountainous issues in my mind in that jury selection were rich suing rich, why should I care? And the Keck Foundation does a lot of good for the community.
Yeah, and the jury selection was very interesting. I don't know if I've ever had a more people with higher degrees, better sounding jobs than the jury selection that we did. I mean, we probably had what, 4 or 5 doctors in our jury panel. If you know, we lost a few to like hardships or cause, but then the rest we had to strike. We had the juror number 1 who said that he didn't like this case. He was a CEO of a tech company who'd sold his company for many millions of dollars. I mean, you name it, and we had that high level person on our jury panel. So I mean, it was definitely one of those cases where if we hadn't gotten cause challenges, and if Bruce hadn't done a great job of asking the right questions and doing the right kind of follow-up, I think we could have been sunk very easily by a bunch of very difficult jurors, you know, very highly scrutinizing, very analytical people that we were dealing with. So we had to make sure we did a very good, and Bruce did a very good patient job of jury selection. When you voir dire this many people at once and your jury selection lasts this long, it is an exercise in patience and stamina, you know, because
I was exhausted.
And I've seen it before where lawyers get to, you know, juror 25 and they just ask one question and sit down because they're tired of the process. And Bruce did not do that. And I'm very thankful for that, because when we did our strikes, we went through everybody in the entire room with the exception of the last 3 jurors. I think that's accurate. I think we exhausted our entire panel. The entire panel.
They had to bring in a second panel. It's like we went through, so we actually had 2 panels at one point as we went.
And on the last day, Judge Lavanis was saying, can we do it with these people, or do we need to bring in another one? Remember? So we literally left 3 jurors, I think, unused when all was said and done. So it was very important to use your strikes and you do your questioning carefully, even when you're tired and it's the last few people in the room. So,
hey, Claire, do you remember how many strikes we used?
We were given 9 because Judge Lavanis does peremptories for alternates and the panel together, and we used 8. And we very purposely stopped at 8 because I remember if we used one more, we got to a row of 3 dangerous jurors. So we used 8 and defense used 7, I think. So, and that was one of the, go ahead.
Oh, I was going to say, so we got the jury in place, but there were some real major legal issues in the case and motions in limine, as you can imagine, assumption of the risk, a variety of things. And so that's where Alan comes in to talk with us about how he dealt with those issues.
So this is not your typical case, as we said before. It's not like the Bel-Air Bay Club actually clubbed Keck over the head and injured him. Essentially, Keck comes into the locker room already suffering from some heat-related illness, and the argument here is that, well, the club is negligent for failing to act in certain ways. And you're going uphill against the basic concept in court law, which are all taught, which is, generally speaking, unless you cause the harm, you don't have a duty to act. And that was the big thing they were saying in motions in limine. Look, we don't have to do anything. We don't owe him a duty. They were a bunch of motions about that subject. So it's very important when we're talking about failing to act, what kind of duties and how you establish duties here for a moment. And so a lot of words, but basically the gist of it is this. He was a member of the club. He was also an invitee on the property, which means that the property owes him a duty because they're already in a pre-existing relationship. And a good case to look at, 2 great cases, they're criminal cases, they're Supreme Court cases. One is Delgado versus Trax Bar and Grill, got the quote there. The other one is Morris versus Delatorre. And the Morris case was really important here because in Morris, what happened was someone got stabbed in a restaurant, and the allegation was that the restaurant should have called 911 timely to get the person medical attention. And the court was like, look, normally you don't owe a duty to call 911, but when one of your customers gets stabbed on the premises, at that point you have at a minimum a duty to call 911. And if there's another Supreme Court case called Verdugo versus Target, which says, hey, look, when we're dealing with medical emergencies on premises, the criminal failure to act cases like Delgado and Morris are important, and they're analogous, and they get used in those cases where you have a foreseeable medical emergency. But the defense was very much about, we don't have to do anything, we can't be required to do anything. And then the question becomes, well, what do they have to do? And the courts are a little bit all over the map on this about what a property owner has to actually do in response to an emergency. But the one thing the court says is, look, you look at burden, the relationship, the standard of care. But what the courts universally agree on is, at a minimum, you have to timely call 911. So they were like, well, you know, we don't have to provide him water. We don't have to do this. Our point was, Your Honor, at a minimum, they had to call 911. And we're going to show you that based on what's going on here, they did not timely in a reasonable manner call 911. And the court was fine with that. And, you know, there were other questions about, well, do we have a duty to give him water? Do we have a duty to move him to a cool place? Do we have a duty to get his consent to do things? And our point was, that goes to standard of care. And they wanted to mix up duty with standard of care. And our whole point was, look, Your Honor, sometimes based on the relationship, you do have to do more. And the standard of care, when you're dealing with an entity like a club, where people are there relaxing, working out, sometimes staying overnight, the standard of care, we argued, is do more than just call 911. It's move them, keep them cool, things like that. So, but if you look, there's a whole bunch of cases you look at, and there's like N.M., which is a criminal case where you can't put in security footage, all these other things. Our main point was, well, look, 911 is the minimum, but plus we'll have standard of care experts who will show the duty goes beyond 911, and these duties are not so burdensome that they can't be done. So now, one of the things the defense wanted to do in this case, and we knew it going in because there was a demand letter that went out before we got involved in the case, and the defense wrote back saying, you have no case. We're protected by the Good Samaritan statute, which is California Health and Safety Code 1799.12. The Good Samaritan statute is basically saying, hey, look, if you come upon someone in medical distress and you want to act, we want to protect you from being held liable. So, for example, someone's choking in a restaurant, or you find someone on a seizure on the road. We want to have people volunteer and not be afraid to be sued if something goes wrong. So they're like, look, Billy Keck had a medical emergency in our premises. We were around him. We offered him water, things like that. We are good Samaritans. But we knew going into the case that there's a big exception to two big exceptions to Good Samaritan. And I've got them highlighted here. It has to be for someone who's doing it not for compensation. Because Billy Keck was a member of the club, the staff members that were helping them were being paid to help them. And so we knew this statute going in ahead of time. So we made sure when we took the depositions to make sure, hey, it was your job to call 911. It was your job to attend to the members. If you didn't do that, you wouldn't get paid. And so that did a really good job in blowing apart the Good Samaritan. The other part is in section C, which I've got highlighted. It says the Good Samaritan law does not alter pre-existing duty. Good Samaritan is canceled out if you already owe them a duty. It's only someone volunteering. And so in this case, we said, Your Honor, it's Delgado, it's Morris. They owe a pre-existing duty. Good Samaritan doesn't go for an out. So right before the trial started, our first motion in limine, which speed up the whole thing, was motion in limine. We don't even want to hear the words Good Samaritan. The judge was like, well, I want to hear some of the facts, but until adequate foundation is raised, I don't want the word Good Samaritan being uttered in front of this jury. And then when we got deep enough in the case, the judge was like, yeah, I don't think this is Good Samaritan. Good Samaritan is out, which was a very big deal because if Good Samaritan's in play, we have to show something like intentional harm or gross negligence, which, although I think we had a shot at gross negligence, would have made things much harder. Another thing that they wanted to argue was assumption of the risk. And so they wanted to say, look, Billy assumed the risk of getting dehydrated and heat stroke from because he was playing paddle tennis that day, and that's what got him ill. And we knew they were going to try to do this. We got a whole bunch of discovery early in the case from them saying, tell us what they should have done differently in running the paddle tennis tournament. Do you believe the paddle tennis tournament should be canceled because of high temperature, that they should have provided more water? And we always were consistent about it. We're not complaining about the paddle tennis tournament. We're not complaining about sports. We're saying after the event was over, he suffered a medical emergency. It may have been related to the sport. It may not have been. But we're not talking about changing the sport. We're talking about what you respond. And this could have been anybody in the locker room suffering from heat stroke, whether they were just on the beach or whatever. Now, there's some good cases here I've got highlighted here, but basically there's primary assumption of the risk, which would wipe your whole case out on summary judgment, or secondary assumption of the risk, which is basically saying comparative fault. There's a couple cases there I've got at the bottom of the slide you can look at later, but the one of them in particular was the Cefaro case, in which someone went to a marathon, got heat exhaustion, and ultimately died because of it. He didn't complain there was something wrong with the marathon because, look, they said, look, that's a normal thing in the sport. You could get heat problems. His argument was they didn't have adequate hydration and medical facilities at the sport, at the marathon, which actually increased the risk and took it out. So ultimately, assumption of the risk was knocked out of the case. They were not allowed to argue it because we made very clear we weren't complaining about the sport of paddle tennis. This was just about responding to a medical emergency, default back to Delgado. No assumption of the risk. Those words were never uttered in front of the jury, which was also very huge. Finally, as usual, when the defense is in trouble, you go attack the character of the witness. So Billy Keck, the evidence was that Billy Keck regularly took marijuana every day. He was a prodigious marijuana user, medical marijuana, but he was a prodigious marijuana user. Also, Billy liked to have alcohol at the end of the day to unwind. He would have at least a beer or two a day, long standing. And also Billy had a couple of other medical conditions. At one point, 10 years before the incident, he had a seizure. There was some arguments about his kidneys, things like that. And the defense were going all over it. So we'll first talk about the big motion in limine we brought, which was about the marijuana. Because Claire, as you'll recall, how did the focus group react to the fact when they heard that Billy was a regular marijuana user?
Not thrilled.
They were not thrilled. So, but the thing is, there's a great case, and the reason why Bruce and I know it so well is because we lived it. It was our case. It's Hernandez versus County of Los Angeles, and there's the site right there. Basically, in that case, they got in the fact that the decedent had used marijuana, but they were unable to link the use of marijuana with the cause of death. And the court said that is third rail, prejudicial, reversed the lowball jury finding. And we were like, Your Honor, look, yeah, Billy took marijuana, but there was no evidence of marijuana in his system at the time. Not a single one of the defense experts could say, well, yeah, him using marijuana the day before or being a regular marijuana user had anything to do with his death. And as a result, the court said, agreed, marijuana is out. Same thing with Billy's use of alcohol. No evidence that Billy had consumed alcohol. He had consumed alcohol 24 hours before, but he had not consumed it that day. He's like, they don't need to know that he took alcohol a couple times, was a regular drinker of alcohol. He didn't have anything that day. The Hernandez case was really helpful in screening all of that out. Same thing with some of the medical conditions. The seizure was irrelevant, nothing to do with cause of death. So by the time we got to the jury, they weren't hearing about marijuana. They weren't hearing about alcohol. They weren't hearing about some of these other weird, spooky, irrelevant prior stuff, so that the usual defense of throwing up a whole bunch of stuff and hoping it would stick are all out, because none of their experts could lay the causation. And finally, this is the standard instruction we put up just for legal issues, because a lot of jurors sometimes get confused. Well, you're suing the club, but isn't the employee of the club who messed up? So this is basically our reformulation of respondeat superior, liability. And basically the jury gets told, hey, look, the club is responsible for any harm caused by the negligence of its employees or agents. Really helpful to have, so you don't get those really weird questions at the end. Well, the club didn't do it. It was the towel person's fault. And why is the club responsible for that? So with that, I think I'll turn it over back to Bruce now.
Okay, so here is how the case went in terms of the presentation to the jury. So the overall case frame, as my friend Mark Mandel would call it, this was about the value of safety. There was a lot loaded into that phrase, the value of safety. I knew at the end of the day that the determination of proper safe conduct would have to be translated into the value of this loss for a woman with a lot of money. The subframe within that was better safe than sorry. We learned that from focus groups. It's something that everybody believes in, and you'll see how it applies to this case. So the way we put it together was, in the locker room where he was for 3.5 hours deteriorating before 911 was finally called too late, in the locker room, there were a number of people who passed through, but there was no video camera. So there was no way to lay out through a video camera what he looked like hour to hour to hour and how he was deteriorating. What we did have was, we had timesheet records, we had videos from outside the locker room to see when certain people went certain places. We had eye recognition technology to know when a particular important, as it turned out, member came into the locker room, or at least into the club, and that allowed us to pinpoint various times that things were going on. So with a lot of that kind of information, we were then able to take the testimony from these various people and plug it into various times during the day. In other words, what did he look like then? What did he look like then? What did he look like then? Minute by minute, hour by hour, as he deteriorated. The timeline here was really important. Okay, so we started out by letting the jury know this is the hierarchy of people whose names you're going to be hearing. If you start down at the bottom, the lower right, you have Dan Harvell and James Cummings. Locker room attendants, they were there the whole time. And then you just go up the organizational chart, and we'll come back to this, as we did many times during the trial, to keep it all straight for the jury as we unfolded the timeline of what happened. So the overall point that the jurors could not get over in the end, as Mark Mandel would call it, the I just can't get over that fact issue, was that he started having his problems at 1:16 in the afternoon, and they didn't call 911 until 4:59 p.m. That was ridiculous. And that was the fact that the jurors could not get over in the end. So we started off by laying out the rules that the Bel-Air Bay Club had in its own manual. There's the cover of the manual. Next. And there you see, for heat exhaustion, what are you supposed to do? Go down and look at instructions. The second one is move the victim to a cool place, but protect him from chilling. As you'll hear, they never moved him to a cool place, and they had one just down the hall in the building. Look at the fourth one. Call a doctor or paramedic. Okay? So, heat exhaustion. Remember that term, heat exhaustion. You move the victim to a cool place, you call a doctor or a paramedic. That's in their own rules. Okay? But we took it a step further. Next. We also had the American Heart Association training workbook. And that workbook was the workbook that had been used by a man named Glenn Kovacs, who you'll hear from in a minute. He used that booklet to train the limited number of people at the Bel-Air Bay Club that were trained. Now, let me make this point. They didn't train everybody, and they didn't train the attendants, but they did train a few of the people at the Bel-Air Bay Club. That was their policy. It wasn't nearly enough, as you'll see. And this is the booklet that was used to train people. Some things within the booklet. Signs of heat cramps. Look at the signs of heat cramps. Muscle cramps, sweating, and headache. You're going to hear about 2 of those 3 symptoms very shortly, starting at about 1:15 or 1:30 in the afternoon. Muscle cramps and sweating. Look at the last sentence. Heat cramps are a sign that heat-related problems may continue to get worse if the person doesn't take action. You're at the front end of the problem, heat cramps, and already the Heart Association manual that's used to train a few people at the Bel-Air Bay Club at the time, already they're saying, you've got heat cramps, you know, it can get worse real fast, take action. Now, we haven't even gotten to heat exhaustion or dehydration yet. That's just heat cramps. Next. Actions to take for dehydration. That's the next level up. If you suspect that a person is dehydrated, contact a healthcare provider right away. Well, that's like 911, a healthcare provider. The best first aid for dehydration is prevention. Make sure a person drinks and eats enough to stay hydrated. So here we are, hydrated. Contact dehydration, contact a healthcare provider right away. Then when you get to heat exhaustion, things are really getting dangerous now. Look at the first sentence. A milder condition such as heat cramps can quickly turn into heat exhaustion. That's why it's important to recognize and give first aid for heat-related emergencies early. In other words, don't hang around hoping that things will get better. This is dangerous territory, people. Take action, and take action now. They even list the signs of heat exhaustion that are similar to those of heat stroke, which is the next level. You don't need to have, and we got all the experts on both sides to admit it, you don't need to have every single one of these symptoms to have heat exhaustion. But look at the last 3. Muscle cramps, feeling faint or fatigued, and heavy sweating. All of those were going on for 3.5 hours before they finally called 911 when the man was having trouble talking. Actions to help a person who has heat exhaustion. Look at number 3, heat exhaustion. Phone 911. I mean, how many times could they be telling us when you're into heat cramps, when you're into heat exhaustion, when you're into dehydration, call a professional, 911. By the way, there was somebody who had training, a lifeguard, who worked for the Bel-Air Bay Club. And you'll hear in a few minutes what happened when they called him. Okay, so when to phone. As a general rule, you should phone 911 and ask for help whenever someone is seriously ill or injured, or you are not sure what to do in an emergency. Wait till you hear what that lifeguard said to the administrative people when they called and said, what should we do? Look at that again. That's from the Heart Saver manual. You are not sure what to do in an emergency. You call 911. Next.
Now, Bruce, wait, before we go for 1 second. The defense lost their mind over this page in particular because it has the word in, as a general rule, and they were like, uh-oh, reptile, they were freaking out. They moved to try to exclude all of this. They were saying, hey, this is a statement of the law, it's inconsistent with California law. We thought that was wrong. But our point was, look, this goes to notice and this goes to standard of care. And the judge was like, yeah, they were trained on this. This comes in. But the defense was very unhappy with all of this.
Yeah, so, but it clearly was relevant, admissible. It's the manual that was used by the people that they hired to train a few of their people at the Bel-Air Bay Club at the time. So, and we deposed him, by the way. Alan did a great job with that. Okay, so why do I have this ribbon here? This is a signifier that we were struggling before trial to figure out a way graphically to present this sequence of events on a timeline. We played with multiple clock faces. We had all kinds of stuff we were trying to use. And then we realized the KISS principle tells us to keep it simple, stupid. So what we did is we used a ribbon. Remember, they've already seen that clock face of 1:16 and the clock face of 4:59 when the call was finally made. So they already have that at the beginning of opening statement, at the beginning of trial. They're getting that all over and over and again during the trial. But now we've got to show them how these different witnesses in the non-videotaped locker room, what they're seeing and what that means. So we start at 1 o'clock, he finishes up and he's qualified for the next level of the tournament. He's done a great job that morning, but it was a very hot day. It was estimated that inside the locker room it was 100 degrees and there was no fan or air conditioning in the locker room. It was September 3rd, Memorial Day, Labor Day weekend. Labor Day? Yeah, Labor Day weekend. Okay. So I mentioned we had some videos and things from outside the locker room. Here he is, Billy Keck. And this man is drinking water, isn't he? So we were able to still shot that at 1:08 p.m. He's going to walk out at 1:10. He's going to walk out and cool off for just a few minutes in the ocean. And next, we know it's just a few minutes because at 1:13 he's leaving the ocean. Next, at 1:16 we see him up on the deck, headed to the locker room. He's probably 20 steps away from the locker room at this time. Billy Keck at 1:16 p.m. has no idea that he's going to be dead before sunset. 1:30 p.m. Let's look at what goes on with Dan Harvell and James Cummings, who were the two locker room attendants down at the bottom of the hierarchy chart. Here's the locker room. What happened was Keck started to complain of cramps. And so he laid down on one of those benches and started to ask for massages from Dan Harvell. Harvell's testimony. So you first saw Mr. Keck that day at about 1:30, 1:45, somewhere in there, correct? I believe that is true. And what you saw was he came over to you and told you he was cramping and that he would like you to massage him, correct? That is correct. Okay. So we had from him that by 1:30, 1:45, he starts the massaging. Spoiler alert, you're going to find out that he continued to massage Dan Harvell, to massage Billy Keck for the next 3 hours. Could not make the cramps go away. 2 o'clock, he's still doing it. Why do I put 2 o'clock there? Because our experts said that after 30 minutes of this and the cramps are still there and he still wants the massaging, that's the time that you're in trouble. It's time to get a medical professional involved. 2 o'clock, that's what our experts said. Their experts said 2:30, as you'll see. Next, 2:30 p.m. Harvell. So what happened is because the cramps were not going away, even though you were massaging him, you began to become concerned about what was going on, right? Yes, I was concerned that his cramps were not going away fast. And in fact, and this was so important too, you were also concerned that his cramps were spreading from one calf to the other calf to his upper legs and now at least to one arm, right? Yes, 2:30 in the afternoon. Not only are the cramps not going away, not only is he still sweating, not only is he still asking for massaging, but it's spreading. The cramps are getting worse. Rule of thumb. I said our expert testified 30 minutes and you start to get people involved. Their expert tried to stretch that and said it's an hour. But once an hour goes by, you've got to take action or else the person may be headed to severe injury or death. So Dan Harvell's testimony. Here we are between 2:30 and 3 o'clock is the way it all fits together once we put that all together. All of these things gave you enough concern that you asked Mr. Cummings. Remember, Cummings is his mate in the locker room. You asked Mr. Cummings, your fellow locker room attendant, whether he might check to see if one of the member doctors would come and take a look, right? That's true. So at 2:30 to 3 o'clock, even Harvell, who hadn't been trained about all this, wants to have a doctor look at this. And there was a doctor working out at the time in the gym right down the hall. Did they go get a doctor? No. Next. Harvell, and that's also about when you contacted Mr. Porteous to let him know what was going on, right? That's right. And Porteous, look at where he is. He's the lower club manager. There's two buildings, one on the north side of the highway, one on the south side of the highway. Okay, and this is the one on the south side where the beach is. Porteous was the manager of that, and he was alerted to this between 2:30 and 3 o'clock in the afternoon, and he didn't take action. He didn't even go look at the manual to see what should be done. So, Cummings, didn't you tell us in your deposition that you talked with Harvell about whether you were dealing with a serious condition here? Yes, I do think we had a discussion, sort of. Question. Now, when you said serious condition, you were talking about a serious medical condition, right? Yes, I think so. Here are two guys that are locker room attendants between 2:30 and 3 o'clock, an hour to an hour and a half after this has started in the locker room, talking about this may be a serious medical condition. Why isn't somebody doing something? Cummings, he appeared to you, that's all we can ask, but you know, you weren't inside his mind, but to you he appeared fatigued, right? Yes. Why am I throwing that up there? Because between 2:30 and 3 o'clock, Cummings could tell that he was fatigued. And remember, one of the elements of heat exhaustion is fatigue. So we were establishing the elements right out of the manual that they were trained with. Next. So then Cummings admitted this. You didn't just say 911 to him, meaning to Harvell. You didn't just say call 911 to him. You said maybe he needs to be in a hospital, didn't you? The answer was, yeah, I believe I said something along the lines of, I think, does he need to go to the hospital, I should say. By the way, Cummings also admitted that he said that to Cassidy, who was his superior. Nobody got him to a hospital until it was way too late. We're still in the 2:30 to 3 o'clock time frame. Next. Your thinking that he should go to a hospital was based on what you were looking at right in front of you, right? Yes. Now, the reason I asked that question was, again, we didn't have video. So what I was trying to do was to bring the events that day to life in a timeline sequence for the jury and to put them into his brain, looking at what he was looking at between 2:30 and 3 o'clock, and knowing that what he was looking at was making him think hospital time. Cummings. Next. So we get to 3 o'clock. Now there's going to be a conclave. And Mr. Porteous, Mr. Bacon, various people are finally going to come to see Mr. Keck. I'm sorry, not Porteous. Mr. Bacon and some others, about 3 o'clock, come to see Mr. Keck in the locker room. It's now been an hour and a half. Remember that whole thing about whether he was ever asked whether he wanted to be moved to a cool place or whether he wanted 911 to be called? We had to ask the various witnesses who were there whether they ever heard Mr. Keck being offered 911 or Mr. Keck being offered to be moved to a cooler room. So, Dan Harvell, of all the people, including yourself, who were in the vicinity where Keck was laying that day, did you ever hear any of the people say, Mr. Keck, would you like us to move you over to Mr. Cassidy's office where it's air conditioned? And he said no. He never heard that, and he was there all day. Next. There was also, before you look at that, it's already up, but that's okay. There's also that argument that he was declining 911, refusing 911. There was a lot of controversy about whether that was true. And of course, one of my arguments was the poor man's dead and he can't come back and fight back against these people that are saying, oh, I told him 911 and he refused. I don't believe they offered 911 to him, but let's look at what that manual says. If the person refuses, phone 911 and stay with him until help arrives. In other words, don't rely on somebody who may be incapacitated or who may be trying to tough it out, especially a male who's just, well, you know, doing well in a tournament. Don't rely on that. The rule says person refuses, get 911 anyway, and let them deal with it. So then HARVELL. So when the superiors came in, did any of them ask you, how long has this been going on? No. Wow, think about that. The superior comes in, sees Mr. Keck down sweating, sees him cramping, sees the massaging going on, and doesn't ask how long this has been going on? Stunning. Kovacs, remember, was the trainer that used the manual to train some people at the Bel-Air Bay Club. Kovacs admitted, and you want to know how long the person has been in this condition, correct? Answer, that would be one of the questions. How long? What's been going on? What's the situation? Well, we just saw that they didn't ask how long this had been going on. Next. Okay, look at where Brennan Cassidy sits. He's the athletic director. Under him is Troy Austin, the men's locker room supervisor, and then HARVELL and Cummings. Okay, go to Cassidy now. You don't remember Mr. HARVELL telling you that he had offered 911 to Mr. Keck, do you? Answer, I don't remember. HARVELL was trying to claim that he had, but he hadn't. And nobody heard him do it either. So Rudy Bacon's the head of security. So he, at around 3 o'clock, tried to make it seem like Keck was doing fine. I thought, like I always thought when I saw him in the locker room, he was laying there cooling out. The only thing that drew my attention was they moved the bench and Dan gave him a massage on his calf. Oh, not a big deal, la, 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 right? However, member Mark was going through there at the same time and saw Billy Keck. The opposed member Mark used him at the trial as well. And watch what he says.
And before you get there, Bruce, Rudy was like a really friendly guy. He was like, oh, I knew Billy Keck for years. We would joke around. He's the Kecker. I would have known if something was wrong. Everything looked great. And he made a nice presentation until you ultimately ended up impeaching him 6 ways to Sunday.
So this is the first time member Mark sees him. Can you describe what was going on? First time I saw him, my general, he didn't look great. He was lying down, and that the two people from the club, they were using some liquids, but my general memory is when I first came through, he didn't look great. Now that's at around 3 o'clock. So that right away impeaches Rudy Bacon, who says, oh, he looked fine to me. It was the Kecker, and what's the big deal? Next. Can you tell us, after you asked Dale Porteous and Rudy Bacon if Billy was okay, what the response was? The response was something along the lines of, he's dehydrated, but he's going to be fine. Wait a minute. This is 3 o'clock. Remember, the manual says if somebody's dehydrated, call 911. This can deteriorate very quickly into a real problem. Next. Why is all this happening? Number one, lack of adequate training. They should have trained all the people that would interact with members of the club that were going through any kind of stressful activity. They didn't. Lack of adequate training. Number two, lack of drills. What does that mean? When the people are trained, you keep their skills moving forward and solid and together and functioning by drilling them. All of a sudden, have somebody act like they've had heat stroke. What do? And you test everybody and make sure that they know what to do. You send them out with drills to figure out how to deal with some problem that's come up. And if they don't know, you sit down and you counsel them on how to do it. They didn't do any of that. Lack of communication. That very act of not asking how long has this been going on was a stunning lack of communication and inquiry, where information that the attendants had should have been provided to management. Next. So we get to 3:30. Now we can pinpoint something here with a doctor member because of Rudy Bacon's picture at 3:34 p.m. taken from the video. Next. What we're able to pinpoint was Dr. K, who is a member, says he went to Bacon and told him he appeared in some distress. He was having his legs massaged by the attendant. He was complaining of muscle cramps. Now that's around 3:30. Now we're 2 hours into this and a half an hour since Rudy Bacon had been up there looking at this going on. Why did you go down to the front desk? Because I thought the locker room attendant was in over his head in trying to take care of Mr. Keck. Well, what made you think that? Well, just the level of Mr. Keck's distress. He was flushed. He looked uncomfortable. He was red and sweaty. This is a doctor member going to the front desk and telling them this. You'd think they'd call 911? No. All this stuff about not being willing to have 911 call. Glenn Kovacs, the person again who trained using the Heart Saver manual. But if they are not given permission and they are getting worse, saw before he was getting worse, the cramps were spreading, the answer would be yes, they would want to call 911. Kovacs again, so if the person long-term is not getting better, and even more so if the person is getting worse, even if they refuse aid, you tell in your class, call 911 and let them deal with it, right? Answer, when in doubt, I would say call 911. 345, we're getting close to something called the point of no return. One of our experts believed that 4 o'clock was the point at which they were not going to be able to bring him back. He was falling so quickly, so badly. One of their experts said 4:30, that if they'd gotten the paramedics called by 4:30, the man's life would have been saved. So let's look at what happened. 3:45, Cassidy comes back up to the locker room. And so what you did was a little bit before 4 o'clock, you went back to see Mr. Keck a second time, right? That's correct. He was still sweating, right? He was still sweating. This man's been sweating since 1:30 in the afternoon, and it's now almost 4 o'clock. Next. Did it strike you, though, as unusual that he had not moved his position in over an hour? Yes. Why? Because I wanted him to be up and moving, at least get in the shower or come to my office. I mean, call 911. You had not seen any improvement between the first and second time, and he was still sweating, right? Yes. Okay, so now we're going to get to between 3:45 and 4 o'clock. And I told you before, we're going to hear from the lifeguard, right? So Brennan Cassidy, athletic director, decides at this point near 4 o'clock to contact Alex David, the lifeguard. He tells Alex David, who's out there at his lifeguard post, what's going on. And here's how that went. Mr. David said to you, I'm the only lifeguard for this particular post, and I can't come up there right now, right? That is correct. He couldn't leave his post. He was the only lifeguard out there. And then he, meaning Mr. David, said to you, meaning Mr. Cassidy, if you are uncomfortable at all, call 911, right? That is correct. Did you call 911? No, I did not. Next. Man, the value of safety. 4 o'clock. So if he had called the paramedics at 4 o'clock, Mr. Cassidy, and they had shown up even then, by that point, our experts said the situation was still salvageable. See, what was happening was, as this was developing, Mr. Keck's body was beginning to develop more and more potassium affecting his heart. 4:15 p.m. There's Dale Porteous, lower club manager, right? There's a picture of Dale Porteous at 4:23 p.m. I told you before, there's no fan in the locker room there, no air conditioning. At 4:23 p.m., hours into this, in a 100-degree locker room, according to the report of the paramedics when they finally got there, at 4:23 p.m., Mr. Porteous is carrying the fan from his office up to the locker room. Now that alone is stunning. But what that also allowed us to do is the presence of the fan and Mr. Porteous and Mr. Bacon in the locker room allowed us to pinpoint the second time that member Mark was there. So Bacon says, this is about that time at about 4:23 to 4:30. Mr. Keck was laid back. His response was laid back. He was laying on the floor with his arm above his head like he was relaxing. And he responded to me in his usual way, and that was malarkey. Member Mark says, second time I went to my locker later in the afternoon, Billy was still there. I just noted that he was still there. He was lying on his side. He looked out of it the second time. And by the second time, there was a fan, kind of a large fan that had been put kind of next to, where Rudy and Dale Porteous and Billy were. So now you had the fan, Rudy, Dale, and Billy all in the same place. And next, member Mark says, I thought he looked worse the second time. I thought he really looked out of it the second time that I was there. This is in the face of Bacon saying he looked fine. He was responding normally. Malarkey. He was a little over an hour away from his death. Next. 4:30 p.m. Finally, Harvell gives up massaging, and look at what he does. Harvell, and what you did was, because at that point he was still sweating, you picked up a towel at around 4:30 and started fanning him to try to cool him down. It was your perception and the reason you started fanning him. For the whole period of time, he never cooled off, right? Answer, yes. Cummings, 3.5 to 4 hours later, he was still sweating, wasn't he? Yes. Cummings, did you ever hear Mr. Keck, who has now passed away? I'm emphasizing right there that he can't say what really happened. He's dead. Did you ever hear him all day that day refuse a call to 911? Answer, I never personally heard him refuse the 911 call. 4:59 p.m. Now, I had Mr. Porteous on the witness stand. Mr. Porteous is claiming that he did not know that there was heat exhaustion going on here. He says he got a call from upstairs saying, please call 911. So here's what happens. Dale Porteous at 4:59, while everybody else is over there working on the planning for the party that night that they were going to have at the Bel-Air Bay Club, while Mr. Keck is upstairs in the locker room getting close to death, Dale Porteous gets that request to call 911, and he calls 911. And he was claiming on the witness stand that he did not know that this was heat exhaustion. Let's listen to what I played back to him at trial.
Absolutely toss it.
16800 Pacific Coast Highway.
Okay, is that a house, apartment, or business?
I'm sorry? It's a business.
It's a business? What's the name of the business?
Yes. Bel-Air Bay Club.
Okay, phone number 310-230-4700.
Yes.
What's the emergency?
We think someone has heat exhaustion.
Are you with that person now?
No, he's in our locker room. I'm 150 feet away.
Okay, and about how old is he, do we know?
60?
60, okay. Do you know if he's awake?
Sort of. He's conscious. He can almost answer you, but he's been laying there for an hour and a half. He is awake.
Okay, and is he alert? Does he answer questions correctly?
No, he's not answering questions right quick. That's kind of our worry.
Do you know if he's breathing normally?
No, he even said he's having a hard time breathing.
Okay, hard time. I'm asking for CPR purposes. I want to know if we need to do CPR. Is he breathing normally?
Yes, he does not need CPR.
Okay, so he is breathing normally then. He's just having a hard time.
Yes.
Okay, and if you looked at his chest, would you see his chest rise and fall normally?
Yes.
Okay, all right. Fire department's on the way out there. Nothing to eat or drink for him. Don't stand him up or walk him around because he'll pass out. Anything changes before we get there, call back 911, okay?
Okay.
All right.
Thanks.
And number two, he said it was only for an hour and a half because he'd never asked how long has this been going on at 3 o'clock. And even if it was an hour and a half, why are they waiting an hour and a half to call 911? So getting back to the main theme, 1:16 p.m. leads to 4:59 p.m. and they finally call 911. You know how fast 911 got there? Next slide, please. Called at 4:59. Next. They're at 5:03. 4 minutes away this whole time was 911. And by the way, they never called Kitty Keck to tell her what was going on at the club that she was also a member of. Next. 5:03 p.m. Here are the paramedics arriving. 5:22 p.m. Here are the paramedics departing with him. Over to UCLA. He has hyperkalemia. That's the elevated potassium, which leads to an arrhythmia. They could not revive him at UCLA. By 5:58, he was pronounced dead. Comparative fault. Alan?
So they were doing a number of things for the defense. The first thing the defense was doing is he's at fault for turning down 911. I think ultimately we were able to show that that's just not right. And on top of that, we had evidence that showed that, people sometimes are not in their right mind, even if they turn down 911. If there's a problem, you call 911. The other big argument, though, they did make was they said, hey, look, he was playing a rigorous game of paddle tennis, which is sort of like tennis. It's just on a smaller court out in the heat. He had been going for several hours. He had not properly warmed up, not properly hydrated, not properly cooled off. He had not done the things that he was needed to do. And so they were basically saying he put himself in this was a induced medical emergency caused by his own negligence. So, and our point was, look, that is a foreseeable thing that happens when you're at a club, by the beach on a hot day, Labor Day. You have to be expecting that. But of the two, we did eventually, and we said, look, if you're going to find some comparative fault for Billy not doing a great job taking care of himself during the day, we understand you can do that, but don't buy this idea of him turning down 911 or turning down, being moved to a cooler place. Ultimately, the jury awarded, we'll get to the damages part, but they ultimately found 20% comparative fault against Mr. Keck, which, based on how well we had done it, we had picked up in the focus group higher percentages of fault. So by the time we got to trial, we were able to hold it down to 20%, which we thought was very good under the circumstances.
And by the way, a lot of that was because of the good ideas and guidance that came from Claire. And now I'm going to turn to the damages section, where she also had a lot of great ideas that we incorporated into what we were doing. There was a particular issue in the damages picture. I mean, already, in my view, you can be quite upset with the fact that this man died at age 48. But the damages, once again, we're back to that question of the worth and of the value to somebody who has a ton of money, the value of safety. Here's some background. Kitty Keck married one of the Kecks. She was from West Texas, and she's actually the president of her own oil company. It's not a giant one, but the jury heard about it because it was part of the story without getting into the details. So the jury knew about a lot of this. There you see Kitty in the yellow with Billy on the horse. He was very young. There you see the second child being born that Kitty's holding, and standing in the front is Billy. Now, let me give you just a little bit of background here. Turns out that Kitty Keck and Mr. Keck divorced. They divorced when Billy was about 12 years old. This is a picture of Billy to the left of his mom when he's about 12 years old. What had happened was that was the year that all of the stuff leading to the divorce and the divorce was going on. And there came a moment at home one night when Billy, as a 12-year-old, physically stood between his mother and his father, protecting his mother. And his father stormed out saying, "You'll pay for this for the rest of your life." That's that boy at the time with the big smile on his face. That moment when he stood up as the oldest child in the family to the father, and I'm not going to get into the details about what happened that led to that, but that moment bonded Billy to Kitty in a unique and special way. And there'd been a lot of testimony about the unique bond that they had, but that moment was critically important. Stop and think about the fact that I said earlier, mostly women on the jury. This is Billy shortly before he died. He was involved as one of the people in one of the Keck foundations in doing grants. One of the grants that he had gotten involved in just recently was for a battered women's shelter. And we were able to get a hold of a video of him. I often tell people in death cases, I'm trying to bring the decedent alive for the jurors in the courtroom. We were able to get a hold of a video. We're not going to play the whole thing, just a couple of minutes. of him talking about grants for this battered women's shelter.
I too want to welcome everyone here tonight to the Bel-Air Bay Club. Personally, I got introduced to the 1736 Family Crisis Center about 2 or 3 years ago from actually one of our fellow chairs, committee chairs, Amanda Harvey. I was able to go down and tour one of the shelters down in Redondo Beach. When I got there, it was, and I go out on a lot of grant site visits a lot, but I have to say that when I walked in to the shelter, everyone I met there was amazing, from the senior staff people all the way down to the therapists and counselors and everyone else. The enthusiasm, excitement, dedication of everyone. A lot of that started with Toby and Debbie, who are just amazing. So I want to give them a big hand. And it's just amazing that there's a facility out there that can help people in that situation. As I toured the facility and met some of the families and friends, you could see the happiness, and most importantly, I felt the security that each of the children and families felt at the facilities. Keep in mind, these are a lot of times, women and children who've, been on the streets or have just been in horrendous situations with abuse and everything else, and didn't have a place to go. Were scared because what were they going to do? They weren't going to go out in the streets, so a lot of times they stay in these abusive situations. And we need more places like 1736 where these families and children and women can go and feel the security. And it's amazing. They provide the food, clothing, shelter. They arrange schooling for the kids. They help out with the mothers with job counseling and psychological therapy, which is amazingly important, just because these women, a lot of times, they don't know what to do. They don't have any idea what their next step is. So that's a very important aspect, I felt, to this, to what 1736 was able to provide, is just the guidance to the mothers so that they can, start on a much, better path. After this initial visit, I immediately knew that this was an organization that I was for sure going to be supporting, and I have personally. Right now, there is a grant proposal in front of the Keck Foundation that hopefully will be materializing as well. So that would be a good thing.
Talk about powerful in the courtroom. The man you're looking at was a loss to his mother after standing up for her when he was 12 years old. It was a loss to the community. It was a loss to all of us. So how did I compute the damages? Remember, one of the big problems we were facing, and we were learning this in focus groups and stuff, was if she has a lot of money, why does she need money? But the other side of that was she is carrying on this fight because what happened here is wrong. And you must place that value on safety. So, the day before closing argument, the defense had a couple of experts on the stand, and one of them was just so bad and charged $3,000 a day for being there from somewhere. So what I said to the jury was, if you think about it, if you try to evaluate what each day without her deeply bonded son is for her, you look at the last 2 years, you look at the next 14.5 years, so you're talking 16.5 years before her probable time of death. It may be longer, it may be shorter. But if they can spend $3,000 a day, if they think that kind of testimony that you heard yesterday was worth $3,000 a day, I got to say $3,000 a day at a minimum must be what Billy Keck was worth to his mom. they've set the standard for you. So you multiply all that out, and it was $18 million. The jury returned a verdict for $15 million, reduced to $12 million by 20% comparative fault. And interestingly, during the discussion afterwards, after the verdict in the hall, one of the jurors said, you know, I just couldn't get over the fact that it was over 3 hours before they finally called 911. Okay. I'm tired now. Go ahead, Alan.
All right, well, I guess I'll take over here for a moment. Let's talk briefly about some of the challenges causation-wise that the defense made. I'll go through them quickly. The defense, we talked about some of them already. Billy refused 911. He looked fine. He was a stubborn guy. You can't order someone to go into an ambulance, and we dealt with all of those. But they're defense lawyers, and they always like to find some medical thing to go for. So ultimately, the defense settled on something called, and I'm not going to try to spell it. It's called rhabdomyolysis. Basically, what they were saying is, we'll get to that in 1 second. But basically, the expert was saying, well, it turned out he overdid it while doing paddle tennis for the few days of the tournament. And what happened was there were muscles in his legs that were breaking down, and it wasn't heat exhaustion causing the potassium spike, but rather it was this thing called rhabdomyolysis that was pumping potassium into his system. That's what ultimately caused the hyperkalemia and the arrhythmia. It's a silent killer. No one could have foreseen it. It's impossible. No one could have ever done it. And so they brought in their experts to say it was rhabdo. And the day before closing, they had their expert on there, their expert, all-purpose expert. And he got up there and look, he made a very charismatic presentation. He's like, oh, it's absolutely rhabdo. This is classic rhabdo. I'm sitting there listening to this, and I'm like, Bruce, kill him. We have a lot of stuff to kill him with. Kill him. Bruce says, no, this is an expert who's going to lie about the color of the sky. If I ask him if it's blue, he'll say it's green. He's the last witness. They're not going to be able to respond if we do a couple things. So Bruce gets up there, briefly gets in there, does a couple surgical strikes. You were wrong about this. You were wrong about that. You didn't read the testimony of our pathology expert. You didn't do this, do that. Lay a couple nice ticking time bombs and then sits down. So what we then get to do is closing. Is before Bruce starts the whole closing, he goes, look, yesterday you heard they were staking their whole case on rhabdomyolysis. They had their expert come in there and say it's rhabdo. Let me go through and tell you why they were not straight with you. This is what the expert didn't tell you. And then if we go to the next slide, they have the autopsy report, which is already in evidence. And what had happened is, basically, if we go through it, they don't find rhabdo. The autopsy report does not find evidence of rhabdo. If we go to the next one, and if we can blow that up a little bit, they actually tested for rhabdo. That was one of the things the coroner did. They tested for. They took part of his leg muscle in the autopsy. Histologic examination of the soleus muscle did not reveal features of rhabdomyolysis. So Bruce then turns to the jury and goes, they bet their whole causation on rhabdomyolysis? They didn't even talk about this? What are they trying to pull? And then if you go to the next slide, and we had been ready for this, and so we had Dr. Fishbein, who their expert had not read, and he had said, look, there was no evidence of rhabdo, and there's the testimony if you want to see it later, if we go to the next one. And again, there was checking out anything. Also, rhabdo causes kidney damage, and the guy hadn't looked at the kidney, and there was no kidney damage consistent with rhabdo. So right out the gate, there was this big dramatic, aha, they are trying to trick you in closing. And we demolished rhabdo to the point where in the defense closing, rhabdo had been defeated so badly, the defense lawyer didn't even mention rhabdomyolysis in closing argument. And go to the next one. And here we go. Again, this is the other thing, though. Rhabdo is not like Ebola. It's curable. If you call 911 on time anyways, rhabdo or not, he's still going to survive. And next.
I think we want to have Claire talk a little bit about the jury we ended up with. so that the people that are watching, now that they've heard the case, can get a better sense of the kind of people who are making the decision.
Okay, so we ended up on our jury that deliberated with 9 women and 3 men. Our 3 men were actually right next to each other. Juror 1, an Asian male, and juror 2, I think they were both Japanese. One worked at UCLA and one worked in like UPS or FedEx. And then juror 3 was a male screenwriter who used to work at a corporate law firm. So he made us a tiny bit nervous, but he asked crazy questions. But okay, juror 4, Caucasian female who was a clean air consultant. She was a defense juror. We all were worried about her, but we didn't have enough strikes for her, and she was not a leader. Juror 5, Caucasian female dog walker. Very liberal lady who had actually lost a loved one very recently, and the defense still did not strike her. Juror 6, Caucasian female nurse. Okay, next slide. And I believe that nurse was the 4-person. Is that correct? I think so. Anyway, juror 7, woman in her 20s, very young, a female corporate recruiter. Juror 8, female TV producer in her 40s. Juror 9, another RN. And then juror 10, female who owned her own business. She owned a painting company. And then we had another 20-year-old software developer. And then our last juror number 12, was a retired teacher, dean of students, strong woman, big leader. And that woman was interesting because during jury selection, she actually volunteered that she does a lot of running. And she said to Bruce, you know, if I was running on the beach and I was suffering from the symptoms of heat exhaustion, I would hope that someone would call 911 for me. And she said that in jury selection, and she was not struck. And I was very pleased to hear that from her because she was such a strong person that I would have been hesitant to leave her on if I didn't know exactly how she felt. And then our alternates, as we said before, we didn't know our alternates before the end of the case. The judge drew lots at the end. And so we had a female stay-at-home mom who was a wife of a doctor who actually got out of a vacation to finish the jury. So it went later, and she stayed. And then a Hispanic male, and then another female who actually had been to the Bel-Air Play Club many times, was independently wealthy. And we were nervous about her, but then she had said many times that she took the death of a child very seriously, and that she felt for Mrs. Keck taking this case to trial, and that she thought it'd be very hard for her, and that she really appreciated the Keck Foundation for all the wonderful things they'd done for the city. So we kept her for that reason, even though she did not strike us as a high damage juror.
And by the way, I just want to say, just to be clear on something, his reputation in the community and the good work he did for the community was relevant to her damages because, as she testified in her deposition, she was extremely proud of the good work her son was doing in the community, helping people. She was very proud of that, and that was part of the loss that she suffered. Alan, one last comment?
A couple things here for a moment. I did see a question here that popped up. It says, did the decedent sign a waiver? The answer is no. There was no waiver issue in this case. Another question that we see here, did you have a fitness...
Alan, let me stop you a second. Whoever that was that asked that question, if you want to get a real strong primer on how to deal with those issues of releases, give Alan a call. We've been down this path on several cases, including to a jury once or twice, and he will give you a lot of background and ways to work on dealing with that.
Other questions I see. Did you have a fitness industry expert? Yes, we did. Our expert was Anthony Abbott out of Florida, and he basically talked about all the standards about what you're supposed to do for training and how to respond. He dealt with and dismantled the defense fitness industry expert and also dealt with Kovacs, who was trying to be a little squirrely. It says, how difficult is it for you to find a fitness industry expert who presents well? It is difficult. And Dr. Abbott is one of the best. He's a true believer on the subject. But, you know, a lot of people in the industry are like, hey, you can do whatever you want, you know, as long as you got a license to do what it is. It is very difficult to find a good fitness industry expert. There was another issue that came up briefly. Bruce kept talking about the value of safety, the value of safety. He drew an objection at one point about using the term value of safety. They were trying to say, oh, it's reptile, it's argumentative, and so on. You can't use the word safety. That's not negligent. That is not true. There was a slide right before the end, I think. If you want to go
Let's go back and get it. Yeah.
Yeah. And basically, again, safety comes from the Casey instructions for premises liability. And the Supreme Court says it's well established that you have to maintain your land in a reasonably safe condition. Anytime the defense, and they've got a canned motion, they do this now all the time. Don't use the word safety in front of the jury. You've got to explain to the judge, no, that is improper. Safety is totally on board. And the judge agreed, and we were allowed to talk about safety. Anyways, go ahead. I'm going to look at other questions here for a second.
You know, another point from this jury selection that we didn't mention that I think deserves a mention is the Judge Lavanis took the jury before we even questioned them and told them about the case, a very brief statement, but he did not tell them to not research the case. And because he mentioned the Bel-Air Bay Club, which is well known, and the Keck Foundation, we had a problem with many jurors researching the case before Bruce even got to question them. So that was a whole nother ball of wax that we had to deal with that I thought we dealt with well, but it was a very unusual situation. And we had, I mean, at least 10 jurors who had researched the case.
I also see a couple other questions here. Did we get our costs back? With respect, did we issue a 998? We did not issue a 998 on the case. I will say the case is now resolved and resolved very, 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 very favorably. But we didn't issue a 998, and we just didn't feel like that was appropriate for this case at that time. It's just one of those judgment call kind of things. We've also got, if there was a waiver, how would you have your chances against an MSJ? So there's a number of exceptions to waivers, which we can talk about later, if you want to talk later about it. But I think we would have overcome a waiver if there had have been, because at 3.5 hours, there was gross negligence. And gross negligence is one of the ways you can get around a waiver. So I think ultimately, even if there had been a waiver, the facts here were so outrageous, we would have survived any challenge. Am I glad we didn't have to deal with a waiver? Sure, but I don't think a waiver would have helped for the defense. Let's see here. How much were the costs on the case? We had three experts. The costs were a little bit higher because there were a couple experts who ultimately didn't testify because the defense at the last minute abandoned a number of their medical causation defenses. But ultimately, we had Dr. Leo, who was our critical care expert, talked about what would have happened had they called timely. We had Fishbein, who was our pathologist, who explained how the damage to the organs would have worked. And then there was also Dr. Abbott, who was our standard of care person. So I mean, the costs weren't crazy. It wasn't crazy, just a lot of depositions and a lot of video. Other questions that are coming up here for a moment. Was Kitty Keck present the whole time during the trial? Bruce, you want to handle that one?
Yeah, absolutely. Let me tell you the reasons why. Number one, she makes a tremendous impression. She's a kind of a stately woman, while at the same time, there's something about her that shows that she's a compassionate woman. It's a very interesting combination. She has dignity, and yet she's not above everybody else in her mind. It's a remarkable combination. I saw that the first time I met her. Number two, the jury knew that it wasn't because she needed the money. They knew it's because she believed something terribly wrong had gone on here. And although she couldn't say it to the jury, she wanted to make sure that something like this never happened to anybody else. So I concluded, Alan and I did, and Claire, all of us together, that she should be in the courtroom. And they really liked her. So yeah, the answer is yes, and those are the reasons why. Claire, do you have any further comment? Go ahead.
I was going to say, we made no effort to dress her down. I mean, she looked appropriate. And I know that she was very worried about having her be portrayed as a wealthy woman. And she even called me, I think, to ask me about it. And we just decided, you know what, there's no hiding it. If anything, the jurors in the focus groups thought she was wealthier than she was, just because of the fact that her name is over everything. So we didn't even bother to try to diminish that in any way.
Other questions we've got. Hey, Bruce, what was the argument or the things the defense made that made you the most nervous?
Bruce can't think
of he's a very good defense lawyer, and so he raised a lot of good points and a lot of good issues. I think that one of them is, I think the big thing that we were fighting a lot was whether Billy had been asked if he wanted to call to 911. We saw that in a lot of the jury research before we started trial. And that was a big focus of the battle. And I'll tell you, I was thrilled to find in that manual where it says, even if the person refuses, call 911 anyway. They did put on a really good expert on the paramedic issue, because they tried to argue that everyone has the right to control their own medical care. And if you choose not to get medical care, that's your choice. And our point on that was, calling 911 is not medical care. If the paramedics get there and then he says, I don't want you even looking at me, then they have him sign off something on that. And then that proves that they said, I think we ought to look at you and check you out. Nothing like that happened because they never called 911. So we argued forcefully that calling 911 itself is not medical care. Though, that expert was a really good one that gave us some concern, but we felt that the I can't get over that fact issue of a 3.5 hour delay was just going to be more than the defense could deal with.
The argument that I thought, or at least there was one time during the trial where my heart started to quicken, where I was really nervous about, was when Dale Porteous was on the stand. He was like, look, I've known Billy Keck for 15 years. We were buddies at the club. He was great to me. I was great to him. And if I had thought for a moment there was anything wrong with him, I would have been on the phone to 911 in a heartbeat. I just didn't think there was anything wrong. And when he was saying all of that, it came sort of toward the end of the week on a Friday as he was responding to some of Bruce's examination. And so right after that moment where I'm like, Bruce gets him to say, so that means you didn't think he had heat exhaustion, right? If I thought it was heat exhaustion, And then right as the day is ending, Bruce then plays the 911 tape where he says it's heat exhaustion. And at that point, I thought Porteous lost all of his credibility. And I was like, okay, he's diffused. And it was right after that moment where Dale had been impeached out of his mind that the judge was like, and we're done for the day. We'll see you on Monday. And it was like, that's what they were sitting on for the weekend. That could not have timed out better. There was another question here, Claire. How many focus groups did we do? And did we do like a generalized focus group or a specific issue related focus group?
You did extensive online focus group, I think, before I got involved. And then we did a one panel, one night focus group where we just heard from 12 jurors and they heard the case and they deliberated. That was the extent of what we did. And I think it was sort of it was pretty close to trial, only a few weeks before trial.
Yeah, it was, I would say, within a month of trial, exactly. And
yeah, we had a pretty good feeling from the online focus group work, and we just wanted to really test it out with a live group and the group dynamics and stuff, and it tracked wonderfully with all that.
And the other thing was illuminating to me is a lot of times you have, there are certain stereotypes about jurors, African-American jurors and defense jurors, African-American jurors and, liberal jurors, you think, they're going to be great. But we had in the focus group, we had one African-American juror who was clearly a very liberal guy. And he took this as, these are rich people. I hate rich people. I hate everything to do with rich people. I can't believe this. I wouldn't be doing this if I was at the 24-hour fitness. I don't go to one of these clubs. He hated the case. And again, so don't look at just the label of, it's an African-American juror or it's a liberal juror. You have to sort of the research that Claire was talking about, looking further on it. So
yeah, and let me comment on something Alan said. Before the trial began, we were very concerned with that notion that You know, they will play up the fact that they were friends, that they knew each other, that they would see the Kecker around there all the time, that they would joke, that why would they do any harm to the Kecker who was like one of their buddies. But during the trial, that didn't really manifest itself sufficiently. There were a couple of times here and there, but it did not become part of the watercolor painting of this trial. It did not wash over the whole case. I don't know how to describe it any differently, but you know, there's certain gists that come out of the evidence, and that was not one of the gists.
Hey, Bruce, did you change anything about your presentation after the focus group?
Yes. Based on the online and the live focus group, our emphasis was going to be on the lack of training. What we saw was the most overwhelming fact in the case was the length of the delay. So what we did was we inverted that and we talked about the length of the delay and then explained the reason that was happening. So you know the slide I had in there that said, why is this happening, question mark? Why is this delay going on? And it lists lack of training, lack of drills, and lack of communication. So it became a secondary factor. It became the factor that was causing or leading to the main fact, which was 3.5-hour delay, unacceptable, ridiculous. So yeah, we did make an adjustment.
So another question we got was, were there surprises, anything a surprise in the trial? And there were a couple surprise issues that sort of happened during the trial. One of which was during discovery, we had demanded to know all the members who had interacted with Billy that day, and the defense had objected, citing privacy, saying it's a private association and we're not going to tell you who they interacted with. As we got closer to trial, the defense realized, oh God, we need some people to come in here to try to dump some dirt on Billy if we can. So at the last second, they said, oh, we're adding 2 witnesses to the list. One was a guy who had seen Billy that morning, but more importantly, had seen Billy be dehydrated a year earlier and sit out in the sun and laying in the sun. And they also wanted to suddenly bring his doubles partner in and say something as well. And we were like, Your Honor, look, this is sword and shield stuff here. They shielded these guys from discovery. They can't now suddenly bring them in at trial. And the judge was like, well, that's true, but I'll tell you what, there was a break that occurred between jury selection. There was a gap in there of a day or two. And he's like, these are quick witnesses, Mr. Van Gelder. If they can get them available by 5 p.m., the next day for depot, take their depots, and then we'll deal with their motions. And so one couldn't get there at time, so the judge struck her. The other guy who saw a year earlier said, well, not only had I seen him having trouble a year earlier, I told Kitty Keck about it. Kitty went over and tried to get Billy to drink some water, and Billy refused. And Kitty said, well, I can't do anything. Billy is a stubborn guy. And we went, Your Honor, this is surprise, plus this is character evidence, it's irrelevant. And so the judge let him testify about that he had that incident a year earlier about being dehydrated, but the rest of it about refusing water and stuff he struck. Let's see here. Did the defense raise an issue about the lack of training not being a viable cause when the employee is acting in course and scope of employment? No, but what they said was instead, they said, look, we trained the supervisors, and the supervisors had all the training, and so they spoke to the supervisors. So it was like they were speaking with people who were trained. Problem is that, as Anthony Abbott said, there's skill decay. We had deposed all the supervisors and asked them, hey, tell us what the signs and symptoms are of heat stroke from the book. None of them could remember. So even the employees who were quote unquote trained, they were so rusty they couldn't remember anything.
Okay, so it looks like we have lost Claire's computer. I want to really thank Claire for being part of this. She did a great job on the case and has on other cases as well. I will say one last thing. What we did a little differently at trial was I wasn't wearing a COVID hair. I had a haircut. I didn't look like this. So get your trial haircuts. I put myself in this camera and going, geez. So anyway, yeah, thank you for being with us. Thank you for your interest. And there'll be another webinar put on by our firm in a couple of weeks. Thanks so much.
Thank you very much.